Good morning, and welcome everyone to the second edition of JustAct Webinar Series. We had received an overwhelming response from the first one conducted in March 2026, and we would like to extend a heartfelt gratitude to all of you who showed love. We heard you the last time. Your participation and engagement encouraged us to present you with this special edition. A lot of questions concern the NBFC and banking sector on hows, whys, wheres, whens, and whats of the disputes that arise out of the financial lending. We have with us today a visionary from the legal fraternity with a vision and mission to make the dispute resolution accessible to any and all, irrespective of their backgrounds, to help answer those questions or concerns. Mr. Rajah wears many hats in the dispute resolution space. With a practice spanning 4 decades since his call to the bar in 1986, including over a decade as a senior advocate of the Madras High Court, his courtroom experience across sectors and courts forms the foundation of much broader institutional and policy influence. Beyond litigation, he has been an active participant at the most significant turns in India's ADR and ODR landscape. He was involved in UNCITRAL's 2013 deliberations on developing a model contract for online dispute resolution, contributed to the Law Commission's work leading to the 2015 amendments of the Arbitration and Conciliation Act, and was a consultee to the Justice Sri Krishna Committee, whose recommendations informed the 2019 reforms. He is also an author, having co-authored Consumer Protection in India with Justice D.P. Wadhwa, written on the history of Madras High Court, and contributed to several key publications. And it does not stop there. He has spent years establishing and nurturing organizations that share his mission of easing the dispute resolution process as founding director of Nani Palkhivala Arbitration Center and founder and director at JustAct. His life and work bridge the bar, policy, institutions, and practice. Please join me in welcoming Mr. Rajah sir to our second edition of on arbitration in NBFC and banking sector. Good morning, sir, and welcome.
Good morning. Good morning. Thank you for a very generous introduction.
No problem, sir. Thank you. So, sir, before we dive into our question, I would like to ask you about your experience so far from 1986 to 2026, which is about 40 years. On how it was in the 80s and how it is now in the general litigation and court areas.
Yes. Well, I'm completing this year 4 decades in the profession. I've seen a lot of it. And what I find quite interesting is that there is an increasing shift from conventional courts to alternate dispute resolutions, as they are called. And there is a lot of interest in developing systems of ADR. So this is a development that I see. I think it's a very welcome development, but it still has a lot of scope for reform and a lot of scope for change, meaningful change, to make the system more effective and efficient. That is as far as the ODR sector is concerned. I feel that with greater literacy, greater awareness of legal rights, there are more people knocking on the doors of courts for justice. But unfortunately, the courts are today overburdened with cases. They are not able to deliver timely justice. And that has become some sort of a public outcry against the system. So the system itself is trying to develop various other methods by which it can ensure that a citizen's right to justice is answered at the earliest, at the least cost and trouble to him. So this is an interesting development that's happening all over the country. And many times you read in the papers that there are close to 5 crores of cases pending. There are inadequate number of judges to hear all these cases, that the law is a very expensive process. The law is a very slow process. And there is generally a sense of dissatisfaction with the way the system is being run. Is the ADR scene matching up to the expectations of the people? Well, my answer to that is, again, we have a long way to go. There are some institutional changes and statutory changes that have to be brought in to improve the system. And Parliament needs to constantly track what is happening in the arbitration regime and quickly respond with changes to the law itself so that confusion is eliminated and predictability is introduced. So this is the way to go. And if you ask me whether this is the way we are going, well, Parliament is responding, but I would think it should respond with greater alacrity and responsiveness itself for this regime to become more effective. Because India is opening up its economy, it's going to invest, it's going to invite huge investments in the economy. And while one would wish that these investments don't lead to disputes, it's a fact of life that they do lead to disputes. So you need to have the second string of the bow ready and working for this, all this to translate into something effective. And that is where I think we are lagging behind. Today's webinar will throw up a lot of questions in the minds of the general public, also people from NBFC and banking sector, as to how effective this ADR system is at all when it comes to NBFC and banking sector. Let's look at that in greater detail as we go along.
Wonderful. Thank you so much, sir. Like you rightly pointed out in the NBFCs. So from your perspective, what has been the single biggest shift in India's arbitration jurisprudence in the last 5 years that NBFCs and banks must now account for in their dispute resolution strategy?
From the standpoints of banks and NBFCs, I would say the single biggest shift in India's arbitration jurisprudence in the last 5 years has been the invalidation of unilateral or lender-controlled arbitrator appointment mechanism and challenges to the same under Section 12(5) of the Arbitration Conciliation Act, led with the 7th schedule to the Act. That, I think, is the most significant development which has hugely impacted the NBFC and banking sector.
Absolutely true, sir. So with the one which you said, the unilateral appointment of the arbitrator being void ab initio, which is the Supreme Court's recent judgment in Perkins Eastman, and on November 8th, Chief Justice Chandrachud sir's latest judgment. How should banks and NBFCs redesign their standard loan arbitration clauses that currently allow the lender to appoint the sole arbitrator or select from its own panel?
See, you must take note of primarily 4 judgments in this area. The first is TRF Limited versus Energo Engineering Projects, which is a 2017 judgment of the Supreme Court, where the Supreme Court held that a person who is ineligible to act as an arbitrator is also ineligible to nominate an arbitrator. So that was the first significant judgment. This was then followed by the judgment in Eastman Perkins, which is a 2019 judgment of the Supreme Court, which said that a party which has a unilateral interest in the outcome of an arbitration cannot have the exclusive right to appoint a sole arbitrator. So this was the second rung of the changes which the Supreme Court brought in by interpretation of Section 12(5) and the 7th schedule. The Supreme Court itself did not pull out these principles from air. It was by the interpretation of the provisions of Section 12(5), read with the 7th schedule to the Arbitration Conciliation Act, that these principles followed. Then in Bharat Broadband Network Limited versus United Telecoms, which again is a 2019 judgment, the court said that ineligibility under Section 12(5) is automatic and mandatory and can be cured only by a post-dispute written waiver by both parties. It said that under Section 12(5), after the disputes have arisen, it is all right for parties to come together and sign an agreement which says that one party would be entitled to appoint an arbitrator. That, as you know, it may have legal sanction, but in practical terms, it's not going to happen, because after the disputes have arisen, both parties are not going to agree on anything, leave alone the appointment of an arbitrator process. So that is really something that's not going to yield any results at all. So it's almost as if it is non-existent. Then in Jaipur Jilla case, the court reaffirmed that where the arbitrator or appointing authority is ineligible, courts may ignore that part of the clause and appoint an independent arbitrator under Section 11. Now, this part is very important because there is a general understanding, or rather a misconception in the NBFC and banking sector, that if they have an arbitrator appointment process by which one party is given a right to nominate an arbitrator, or the process is skewed in favor of one party, then the arbitration clause will cease to be valid. Now, that's not right, because in these subsequent judgments, in Ellora Paper Mills, all these judgments, which is the 2022 Ellora Paper Mills versus State of Madhya Pradesh, in all these cases, the Supreme Court has affirmed that the clause does not cease to exist. It's only the method of appointment of an arbitrator under that clause that ceases to be valid. So this is one aspect which NBFCs and banks must understand. So how do you rectify it becomes the challenge.
Right, sir. So in relation to the ongoing conversation around mandating explicit consent from the parties, like you rightly pointed out, Section 12(5) for the arbitration proceedings, what is the status of the millions of agreements with the unilateral clauses within them? And if these cases are not arbitrable anymore, it is detrimental to the Indian economy as well. So what legal recourse is available to the lender, given arbitration is void ab initio and Section 11 is way too expensive to even consider for cases with a claim amount of under 20 lakhs?
Yeah. So I agree with you that this has a significant impact on the the economic scenario, because, see, there are some 20 lakh disputes that happen all over India. I'm given to understand from reading of some of these reports which are put out by NBFC associations that there are close to 20 lakh disputes, which means look at the number of contracts that are entered into all over the country which have an arbitration clause. But about 20 lakhs, I may be corrected if I'm wrong, there are about 20 lakh disputes that happen every year. Now, previous to the amendments to the Arbitration Act 2015, which were then recognized subsequently in the TRF case and the Eastman Perkins case, what has happened is that courts have vigorously started implementing the provisions of Section 12(5) and the 7th schedule to the Arbitration and Conciliation Act. The result of that is, as I said earlier, not that the arbitration ceases to be valid in all these million contracts. The arbitration clause does not cease to be valid in all these million contracts. There are two options that are available to NBFCs and banks which have arbitration clauses in their agreement. The first is a Section 11 application before the court, because since the arbitration agreement itself is still valid, you approach the court and ask for the appointment of an arbitrator. Now, let us examine this process closely. The advantage that NBFCs and banks had earlier with a lender determined process of arbitration was that the lender could name the arbitrator. What fees that he would pay the arbitrator was between the lender and the arbitrator. So things work very well for the lender. You must understand that world over, arbitration rests on two pillars. The first is party autonomy. And the second is least court intervention. Internationally, why India is not favored as a destination for arbitration is because it thinks that both the law and the court system make deep inroads into party autonomy and the fact that it is a court-driven system. So, in fact, I even question the advisability of courts having arbitration center, because it's now become a fad for practically every high court to have its own arbitration center. I have questioned this. I have written articles about it, because I am saying, if you are saying it's an alternate dispute resolution system, and then courts have control over centers that administer arbitration, what is alternate about it? And the government also have their own systems of dispute resolution. What is alternate about it? What is it alternate to? It is alternate to the conventional court system. It is alternate to the dispute resolution systems which governments provide for in their contracts. It's an alternate to that. But then to say we are, swinging to alternate dispute resolution systems, but setting up High Court monitored arbitration center, High Court monitored mediation centers, government monitored arbitration centers, government monitored mediation centers. This is swaying widely away from these two principal concepts of party autonomy and least court intervention. This is why India is getting a bad name in the international arena in respect of the arbitration regime. It is to answer this that a few of us got together, Mr. Arvind, myself, Mr. Mahalingam, who was the chief financial officer of TCS. We all got together and started the Nani Palkhivala Arbitration Center in 2005 because we felt that there must be an independent organization world over, like the SIAC, like the ICC, the International Commercial Chamber of Commerce, the arbitration wing of the International Chamber of Commerce, the International London Arbitration Center, now emerging Dubai International Arbitration Center, Hong Kong Arbitration Center. All of these are independent organizations which are completely independent of the government and the judiciary. It is with this idea that we formed NBFC, Nani Palkhivala Arbitration Center. And if you really look at similar organizations, and we found that for these arbitration centers to be effective, you need to do it in a corporate sort of infuse more and more technology, like what JustAct is doing. And that's why we then started JustAct, because we are responding to this new way of infusion of technology into legal proceedings, which involves a lot of expense, and we need to maintain large workforce base for that to be done effectively. Therefore, it had to be corporate. But that is primarily the problem. So your first, choice, what do you do? Your question, millions of contracts, what happened to them? Nothing happens to them as far as the arbitration clause is concerned. The implementation of this runs into rough weather. Your first option, go by way of Section 11 application, not a very desirable option, because if you go by way of a Section 11 application, if the court were to appoint an arbitrator, then automatically Schedule 4 fees apply, which is still expensive, right? So the cheaper method by which NBFCs and banks were handling it is goes out of the window. They can't deliver affordable care, to the arbitration process, and therefore that becomes invalid. So what is your other option? What can you do? So I would suggest that the best way to get over this problem is that there must be an addenda which should be circulated to all existing members, or rather borrowers, who have entered into agreements with lenders. Just a 1-page, 2-page document will do, where you set out that because of the judgment of the Supreme Court and TRF, Eastman, Perkins, etc., and taking note of the development in law, and to give a better option to you of dispute resolution of your disputes that may arise with us, we are enclosing an addenda to the agreement. This addenda to the agreement will just have one clause, which will talk about the dispute resolution clause. It will say that the earlier clause was superseded by this clause, and in this clause, we are providing for institutional arbitration. Take care to draft that clause so that you provide for recourse to ODR and everything, which is the emerging technology. Take care to mention all that. Put a well-drafted arbitration clause and send it to all your borrowers. I don't think they'll have a problem in signing that and sending it back to you, because under the terms of the contract that you enter into with them, they are in any case bound to execute any documents that would facilitate the exercise of your rights under the contract. So you send a document to them, get it signed, and keep it in your file. And if there is to be a dispute at a later point of time, then there is a contract which has been entered into by the parties, which is binding on them. Invoke that and send it to institutional arbitration. That is what some NBFCs do, is that they have introduced, or rather after the dispute has arisen, they still refer it. They don't go the old way, the old route, and they don't refer it to the lender-nominated arbitrator, but then they refer it to an institutional arbitration. That will still throw open the case as to whether it was an agreed recourse or whether it has just been sent unilaterally by one party to an institutional arbitrator. That again will pose problems. So the better thing is to send it to, of course, you still have the 12-5 option where you tell the other person that, listen, because of let's take a closer look at what the court has said. Court has said that arbitration clause is still valid. So you are still bound by an arbitration clause. If I take the recourse of going by way of a Section 11 application and the court appoints an arbitrator, it's going to be expensive for both of us. Just not me, it's going to be expensive for both of us. And therefore, because arbitration costs have to be split both ways, and that's going to add to your burden. I mean, you are a defaulter, no, because you are unable to pay the dues to me. And if you have to go to court at a later point of time, and that's going to add to your burden. So be sensible enough, sign an agreement where both of us can agree that we will send it to an institutional arbitration for a resolution of the dispute. So to summarize a long answer, A, Section 11 is your option. Costly, best avoided. B, this requires some action before the dispute arises. Send an addenda to all your borrowers and get it signed by them. Keep it in the file. Activate that when there is a default. C, all right, I don't want to go to Section 11. Take your shot by 12.5. Send a letter to him saying that these are the problems. And here is an institutional arbitration to which I'm referring the matter. Kindly sign this letter and let's set the ball in motion. These are the three options that are available to you given the current scenario. Of course, there is the precautionary principle in arbitration, so to say, in respect of future contracts, ensure that there is a well-balanced, well-drafted, well-crafted arbitration clause, which ensures that there is complete independence and impartiality to the process, and you are not hauled up before court at a later point of time or faulted by the court that this is a one-sided agreement. So actually it is in 4 parts. 3 is what you do in respect of past transaction. The 4th is what you do in terms of future transaction.
Lovely, sir. Thank you. That's a lot of fodder for people to think on this. Moving on, we conducted one webinar last month, the first Saturday of March, and there was an overwhelming response from the participants and in questions for engaging with the speakers. And one of the things was that the Section 34 petitions, they usually can take about 3 to 4 years, even when the award was passed in just a few months, right? Doctrinally and practically. What reforms are needed so that set-aside proceedings do not defeat the core promise of speedy financial arbitrations?
See, I would say, following the judgment in Associated Builders versus DDA, which is a 2015 judgment, and the judgment in Sangyong Engineering Construction Company Limited versus NHAA, which is a 2019 judgment, and the Delhi Airport Metro Express Private Limited versus DMRC, which is a 2022 judgment, you have a regime in place by which your Section 34 applications are to be adjudged. Now, the application of these principles is not a problem. Very rarely do courts swerve from this path set out in these 3 very important judgments. And to that effect, the Section 34 hearing itself can be effective. But your problem, the problem that you have voiced is, it takes such a long time for a Section 34 application to be decided. So what am I supposed to do to improve my situation? Well, 2 things that you can definitely do. One advantage is after the 2015 amendments to the Arbitration Conciliation Act, there is no automatic stay of an award that has been passed by an arbitrator or by an arbitral tribunal. Use that aspect to your full advantage and ensure that even if there is to be a stay of the judgment, ensure that the NBFC or the bank is substantially secure by the defaulting party offering whatever it can offer by way of a security. Because your real fear is this, that if this Section 34 application is going to take 4 years to be decided, and you have a further recourse by way of a Section 37 application, what happens to my security?
Right.
So one of the best things that you can do is, if it is a movable property like a truck or an equipment, you must take out an application for sale of that. Most NBFC contracts, they seize the security even with the arbitration proceedings are continuing. So to that extent, there is some security available. If you need orders to sell that equipment and to encash the money, by all means do that. And if you need some orders by which some extra security, let us assume somebody has borrowed and purchased a truck and there is a default, and you are able to sell that truck and his dues to you are, let's say, about 100 rupees. You sell the truck and you recover only 80 rupees. To the balance extent of this 20 rupees, try and get an attachment of some property he owns, so that ultimately when there is an award is upheld by the High Court or even in a subsequent appeal under Section 37, you have sufficient security to meet the decree. So that is the most important thing that can be done. One redeeming feature, I would say, in recent times is the judgment of the Supreme Court in Gayatri Balusamy case, where 4 judges against 1, they said under limited circumstances, it is possible for the court to modify an award. So that, I think, is godsend for the arbitration regime, because otherwise what used to have happened earlier is that the court recognizes that there is some error apparent on the face of the record and therefore sends the entire matter back to the arbitrator and you go back to square one. Now, that is a bit of an expensive process and not a very effective process and hugely cumbersome process. So now there is a limited scope. People should not jump with joy and say that this is almost equivalent to an appellate power. No, it's not an appellate power. Under certain circumstances, the court is bound to rectify. Also, if you find that the Section 34 application can be much more effectively handled by the matter itself being sent back to the arbitrator, because if you find there is an inconsistency in the arbitral award between what the arbitrator has said in one place and what he has said in another place, send it to file an application under Section 34(4) or even persuade the court under Section 34(4), because after Gayatri Balusamy case, that has also become much easier for you. Ask for the court to send it back to the arbitrator or the arbitral tribunal to rectify this apparent error on the face of the record. So that's another facility that you have. But the most important thing is for you to secure the dues to you. Do it by way of an interim order application under Section 30.
Right, sir. Thank you. So, sir, there is a question on the unilateral Section 17 orders from one of our participants. Since we are talking about property attachment and vehicular repossessions, I think I'll just ask you this question so that we can move on to the next from our roster of questions, from the list of our questions. So this is from Ms. Bhargavi. She says she's an advocate, and she says, from the borrower point of view, how do you see the unilateral Section 17 orders passed by the arbitrator, with online arbitrations automating these interim orders and the courts refusing to intervene? It is increasing the burden on the borrowers. She's asking for a way out on this.
See, let us look at what Section 17 is. See, any interim order for that matter is a facility that preserves the status quo. It preserves the property in dispute in an arbitration proceedings. So a Section 17 order, which is passed ex parte, usually it is not passed ex parte, but let me assume it is passed ex parte. So long as it has the effect of preserving the property in dispute or ensuring that the property in dispute, the value of the property in dispute does not get depleted, there can hardly be much of a complaint against that order. And the fact that it was passed ex parte really does not make any inroads into the validity of the order. There can, of course, be orders that have been passed ex parte, which are really not in the nature of preserving the property in dispute, but is more intrusive and invasive of the rights of the borrower. Now, if that happens, you definitely have a recourse by way of a Section 37 appeal to the High Court. But as far as the law is concerned, law on paper is different from law in practice. So, law on paper, you have nothing to fear about. There is no fault with the law on paper. The enacted provision is not faulty. I mean, it only empowers the arbitrator to pass some order because world over, once again, this concept of emergency or arbitration is invoked. So I can very quickly, invoke an arbitral power. Within 24 hours, an arbitrator is constituted. He can ex parte pass an order and to preserve. All this is now directed to ensuring that the property which is subject matter of the arbitration is actually preserved and does not suffer any depletion, does not suffer any, is not extinguished, is not sold during the process, or does not suffer any great change which will make it indistinguishable. These can happen in very many. For example, let me assume that there is a huge, cargo of perishable commodities, which can last only for 24 hours. And then the arbitrator says that sell the commodities and put the money in the bank account. Now, you can possibly fault it as being ex parte and passed under Section 17, but that is preserving the subject matter of the arbitration, because what use is that cargo to anybody if it is going to perish in the next 24 hours? You buy a whole bunch of, let's say, tomatoes or some perishables like that, which run the danger of perishing within a very short time. And therefore, quite inevitably, the arbitrator perforce is constrained to pass an order to sell it and to put it in some bank account. So the circumstances can be various. And the ultimate test is, what is he doing? Is he trying to preserve the status quo? Is the arbitrator trying to preserve the status quo with regard to the property? Is he trying to ensure that the property does not suffer depletion? Does he ensure that there is preservation of the property, which is the subject matter of the dispute? If it answers all these qualifications, then there is no problem with the interim order. And just the fact that it has been passed in ex parte will not actually eat into the validity of the order. But if it is otherwise, then you have a recourse under Section 37 by way of an appeal.
Sure. I hope this answers your question, Ms. Bhargavi. So moving on, sir. In the 2019 Arbitration and Conciliation Act, there is a Section 2CA defining an arbitral institution to mean designated by the Supreme Court or the High Court under Section 11(3)(a). Also vested with the power to designate arbitral institutions from time to time, but this has not been implemented till date. What legal authority do arbitral institutions or ODR institutions like JustAct have in this current state?
See, Section 11(3)(a) of the Arbitration and Conciliation Act has not been notified. Okay, so but even without Section 11(3)(a) not being operational, arbitral institutions will continue to function on a contractual and procedural basis. This is where you need to go back to the fundamentals of arbitration all over the world. Arbitration is a consensual process. Party autonomy is supreme. So if two parties decide that a particular institution must decide our disputes, it's left to them to do that. No, you can't say that parties, I am blessing. The legislature can't say I am blessing this process of arbitration. Supreme Court and the High Courts can't say we are blessing this process of arbitration. But we will frown on any attempt for you to exercise your autonomy. Now, that is not a very advisable way to go. In fact, I don't think there is any legislation in the world at all comparable to our Schedule 5 and Schedule 7 of the Arbitration Conciliation Act. Actually, I was also part of that exercise into the part of the Law Commission which wrote that report. What we did is we actually borrowed this from the International Bar Association list of red categories and orange categories. Orange categories became Schedule 5 and red categories became Schedule 7. Schedule 7 is an absolute bar. Orange is a red flag, so to say. And it needs disclosure, and the lack of a disclosure can affect the rights of parties at a later point of time. So there is today, what is the sanctity? The sanctity is on account, in fact, in judicial endorsement of this in Bharat Aluminium Company versus Kaiser Aluminium Technical Services, Supreme Court strongly affirmed party autonomy. In the judgment, it affirms party autonomy, including the choice of institutional rules. Please read the judgment. 2019 9 SEC, page 552. Including institutional rules, and see it reinforcing that institutions operate under parties' contractual choice. So this contractual choice is sought to be streamlined, I would say, by introducing 11(3)(a), because with the view to ensuring that institutional arbitrations don't go overboard and are not made the handmaid of some process which is questionable and malified. It is only with that this 11(3)(a) is, I hope the legislature understands what it is doing when doing that, because what should come, even after 11(3)(a) is introduced, what should come in the forefront is parties' autonomy. Parties have a right to recognize. You make the institutional arbitral institutions accountable. In the sense, you can say that institutional arbitral institutions must submit their returns every year, must give us a list of all the cases they have done every year. You put them to scrutiny. That's a different thing. But you can't create entry barriers to parties exercising their party autonomy. Because this has been recognized, as it said in Bharat Aluminium Company, it has been recognized in Centro Trade Minerals and Metal Incorporated versus Hindustan Copper Limited. If people are interested in taking down the citation, it is 2017 2 SEC. Supreme Court upheld a two-tier institutional arbitration clause, which you don't see in the Act at all. Again, treating institutional processes as completely valid so long as it is grounded in the arbitration agreement. In Perkins Eastman Architects DPC, which is also 2019 9 SSC, court discouraged unilateral appointment of arbitrator and implicitly endorsed neutral appointing authorities. So Eastman Perkins frowns on unilateral appointment of arbitrators, but it blesses neutral appointing authorities. So long as there is an institution like NPAC or JustAct, and there is no question on the neutrality of these institutions, and these institutions are a product of the contract between the parties and exercise of party autonomy, they cannot be faulted. And they have received the blessings, explicit blessings of the Supreme Court in these three judgments, and also in Amazon.com, NV Investments Holding versus Future Retail, 2022 1 SEC, page 209, where the Supreme Court held that emergency award under the SAAC rules is enforceable under Part 1. So rules of institutional arbitrations have been upheld. The right of neutral appointing authorities to appoint arbitrators have been upheld. The party autonomy in choosing certain institutional rules and institutional arbitration has been upheld. So the legal grounding for this is very, very firm. When 11(3)(a) comes, 11(3)(a) will only supply a procedure where these institutions can go and register. And, I have a constitutional right to free move over any part of the country. But if I have to drive a car, I have to go and get a registration done under the Motor Vehicles Act. Right?
Correct.
It is something like that. Just because I don't have a registered car, it does not impinge on my right to move freely over any territory which is which is India. So it is like that. One is a right, which is a party autonomy, which is recognized by all provisions of the Act. In fact, the Arbitration Conciliation Act itself is drafted to encourage and ensure party autonomy. That has been recognized by the courts in these 4 judgments. And what more do you need? 11.3a
Right.
has still not come in. High courts have still not been empowered to recognize. In fact, NPAC has been recognized under the provision by the Madras High Court.
Right.
Under the Chief Justice's appointment of arbitrator scheme, there is one clause there which empowers the High Court, because under the provisions under Section 6, I think, of the Arbitration Conciliation Act, there are institutions which can be recognized to render administrative assistance in services and arbitration matters. And under that, read with the Chief Justice's appointment scheme, one is the primary provision in the Act, the other is an enabling provision in the appointment of Chief Justice's scheme. There is a provision to recognized institutions, and pursuant to that, NPAC has been recognized. But because there is an attempt to bring in 11.3a, all high courts and the Supreme Court have put the brakes on and said, let's wait for this 11.3a to come into effect. Because legislature has expressed its mind, it has brought a provision, so let us wait for the Parliament to act. In my own opinion, the provisions of the Arbitration Conciliation Act, Section 6, which provides for the existence of institutions that can grant administrative assistance in arbitration matters. I think it is Section 6, I'll just verify. And read with administrative assistance. It says in Section 6, in order to facilitate the conduct of arbitral proceedings, the parties or the arbitral tribunal, with the consent of the parties, may arrange for administrative assistance by a suitable institution or person. This is already there in Section 6. It's already enacted. 11.3a will only attempt to give a regulatory framework to what is already there. But this read, as I said, with the appointment of arbitrator scheme, there is legal power to every High Court and Supreme Court to do it, but they are waiting for the fate of Section 11.3a to sort of unfold.
So, I mean, because of this lack of clarity on the institution, which you clarified very well right now, I think a lot of cases, or a lot of disputes, or a lot of lenders are going through civil suits instead of arbitration. So I think this clarifies a lot.
See, I just interrupt you for a minute. They're going for a civil suit because there is a unilateral appointment process is again invalid. Because Supreme Court has said that the arbitration clause is not obliterated.
Right.
It is only the process. See, you have an agreement in which there is a clause which gives a lender-dominated system for appointment of an arbitrator. All right?
Right.
Now, the arbitration, because arbitration in that clause, it does not cease to exist. That part of the clause is still valid. Okay. So, if that clause is still valid, if you file a suit, your suit is invalid, because the borrower can then go to court under Section 8 and say, there is an arbitration clause, you have sidestepped that arbitration clause, and you are trying to come to a civil court, and he can file an application to stay the proceedings. So this is wrong.
Okay.
I mean, you don't have a clause at all, it's fine. I'm not talking about that situation. But to think, because I have an arbitration clause which allows for unilateral appointment of an arbitrator, I must pull back and I must ensure, I must then take my recourse before the civil court is wrong.
Right. Thank you, sir. I think there's a, we are at 11:45 right now. I'll quickly pick up 2 questions from our list, and then we will see if there is any questions from the audience. So we were talking about arbitrators' powers somewhere in Section 17, etc. So we all know that there are, it's limited. The arbitrator powers and jurisdiction is quite limited.
Mm.
So now in this scenario, does an arbitrator have the power to write a letter to the concerned embassy
Mm.
to impound passport or extradite the person back to India in these cases where the borrowers or someone is out of country?
See, an arbitrator is a creature of a contract. He is not a creature of a statute. He wields no statutory powers, okay, except to the extent permitted under the provisions of the Arbitration Conciliation Act. He is not exercising any statutory powers. So the power to impound or revoke passports is specifically governed by the provisions of the Passport Act 1967, particularly Section 10(3) and Section 10(a) of the Act. So he has no power to order a passport to be impounded. In fact, in Suresh Nanda versus CBI, the Supreme Court has held only the passport authority under the Passport Act can impound a passport. And even courts must act within that statutory framework. See, courts can't say you impound that passport. Court can ask that authority to exercise its power in a manner known to law. And it can say that, as far as we are concerned, on the basis of the facts presented before us, we think that there is ground for the passport to be impounded, but the authority which has been designated with that power, authorized with that power, let them exercise that power and do that. That's what even courts can do. Similarly, extradition is governed by the Extradition Act 1962. It's also, this Extradition Act 1962 is also regulated by relevant treaties, executive, judicial processes, and is a function of the union government and criminal courts, not private tribunals. Because ultimately, you must recognize what is the status of an arbitral tribunal.
Right.
The status of an arbitral tribunal is a private dispute resolution body. That is why under Section 26 of the Arbitration Conciliation Act, powers are vested with the tribunal to allow one of the parties to move the court, even for contempt of court. It can hold that there has been a violation of the order. To that extent, there is a violation of the order that has been passed by a private tribunal. But any further action must come from courts. So you must push the party to courts to seek. That is the scheme of the act. So definitely there is no power vested with an arbitrator to impound a passport or to pass any orders in respect of extradition. Of course, it's open to the arbitrator to pass such orders he deems fit under Section 26, enabling one of the parties to move the court, the conventional courts, for any orders in this respect. But he himself can definitely not pass an order, and writing a letter to a foreign embassy to impound a passport or extradite the person would therefore have no legal force and is beyond the jurisdiction of the arbitrator.
All right, sir.
In fact, if an order is passed, then there is even scope for the High Court to intervene under Article 227 and to quash such an order.
Okay. All right. Sure. Thank you so much, sir, on this. Just the one or two small quick questions. One is there are a lot of questions that keep coming to us when we visit or when we see clients. Is that the ODR platforms handling certificate requests under Section 65B of the Evidence Act? Are we? Do we have the power to certify
the e-stamping?
E-stamping, not e-stamping, sir. All the arbitration proceedings, whatever was submitted by the parties, can an institution certify them under Section 65B of the Evidence Act? Does an institution come under the?
Yeah. See, under the Evidence Act, specifically, I think Section 65B, H1, governs the admissibility of electronic records as secondary evidence. Okay, now you have a new law, which is the Bharatiya Sakshi Adhinayam, and the corresponding provision is Section 61, which talks about admissibility of electronic digital records. Right? Both require conditions similar to Evidence Act, regular use, lawful control, proper operation of computer system, etc. A certificate under the Evidence Act issued by a person is a responsible official position related to the system or activity. See, if I am in control of a computer from which an award is rolled out, then I fall within the definition of a responsible official position related to the system of activity. Then I am qualified to give a certificate. Right. So the two main judgments of the Supreme Court on this issue are Anwar PV versus PK Bashir, which is parties can make a note, 2014 10 SCC page 473, and Arjun Pandit Rao versus Kailash Gorantyal 2027 SCC, which clarifies that Section 65 certificate is generally mandatory where evidence is led by way of copies and printouts. And certificate can be produced later if the device is not in the party's control. In Shafi Muhammad, the relaxation later disapproved was overruled by Arjun Pandit Rao. And the earlier approach allowing moral proof of electronic records was held to be incorrect. So today, as the position stands, let us look at what does an ODR platform like yours have the capacity to certify. You can certify case metadata, you can certify logs, you can certify timelines, you can certify chat transcripts, you can certify video conference logs, you can certify event histories, you can certify e-awards or settlement terms generated signed on the platform. You can certify system-generated notifications, that is emails, SMS logs, access logs, IP logs. For these, the ODR platform becomes a person in control of the system and can issue a full certificate under Section 61. All these you can do because you are in control of the system, and generally all ODR platforms have access to all these.
Right.
And therefore, you satisfy the definition of a responsible official position related to the system or activity. And therefore, you can certify.
Great. That clarifies a lot of, because there was no clarity in I think, Section 65B. Because there were about two people, arbitrator or a notary, who can certify these copies earlier. And this
So the
definitely...
company itself, the person who operates the ODR platform is actually the competent person to certify it. Because he is the person officially in charge of that system. See, the purpose of all this is to ensure that there is no tampering. So somebody must take the responsibility and say that I am in charge of the system. This system has rolled out something which is authentic. That is the purpose.
Right.
It is not the author of the award. It is not the party who is, submitting a document to you. These are not the persons who are responsible. The person responsible is the person responsible for the computer system as such, who must certify it.
Right, sir. Right.
There are also limitations to that. The platform cannot certify how the document was originally created on the user's device. So that you must be careful about what you are certifying also. You can't say that I know this is how it was originally, because you don't know. Something has been originally, created and sent to you.
Correct.
And as an ODR platform, you are just that. You are a platform into which various things are parked or stationed. You can say it is all parked or stationed on my platform. But you can't say, I know the system under which this document was created. You don't. You don't know that.
We cannot certify a loan agreement or a contract between the parties, but we can definitely certify when was it updated, when was it, all the logs and all the audit trails pertaining to a case ever since its inception.
What you need to do is you need to pass a resolution certifying your CTO, usually head of technology for system operation aspects, or the chief compliance officer, legal head for evidentiary and policy assurances. You need to pass and empower them and say that as a policy of this company, these are the persons who will certify for the purpose of meeting the requirements of Section 61.
Great, sir.
And you can put that in your website also. And these are the persons who will be in charge of certifying these documents.
Great. Sure. Sure. So I know you have a hard stop at 12. You have another engagement. So I was going through the questions submitted from the from the participants. I think most of them we have already covered in our uh, line of questions that we had about 50 minutes today. Is there anything that you would like to say to leave the audience with a thought or a food for thought going forward?
One question I'm surprised has not been asked to me is what is the status of AI in all these processes? So I don't know. I'm sure many of the youngsters here have already started using the AI processes for much of the work that they do. AI itself is basically for the purpose of legal studies and legal application is of two general types. One is a general AI and the other is a commoditized AI. Okay, commoditized AI are platform products like Harvey and many things which people are using today. So these are commoditized AIs. What does commoditized AI do? It ring fences the scope of inquiry. See, if you go and ask an AI a particular question, it just goes into the AI open universe and searches for an answer. And it will give you some answer. It doesn't care very much whether that answer is accurate or not. It is a very compulsive technology. It will feel the necessity to answer whatever questions you ask it. Right? But when you use a commoditized AI, it will not step out of the boundary created by that AI and will not come back with fanciful contentions. So that is how, as youngsters, you must decide. Because today I read a lot about institutions, courts frowning on AI-generated answers. This AI-generated answers take a printout and rush to court and produce it before court. It meets with grief because the court is aghast that such an answer has been given when it has absolutely nothing to do with the case. This is because you are pulling out answers from ChatGPT and such general AIs. They don't have the capacity to. So, in a very good talk given by one technocrat recently, he said that the best way to answer these challenges is for institutions to embrace AI. Courts must set a policy. ODRs such as yourself must set a policy as to how you will embrace and integrate AIs into your process. The Supreme Court has done a very good work in January about how courts can actually use AI. Supreme Court is not, frowning on use of AI in court proceedings. In fact, it has regulated the process. So it is wrong to think that conventional courts are against AI. If you go into the website and Google the Supreme Court guidelines on AI, it will pop up. It has given a lot of guidelines about how AI is to be used in courts. So you must, every institution, because it's going to be an explosion in coming days and coming times, because AI is just going to take over and it is a huge saving on time. But you must know what your AI is capable of. And it can really turn around a lot of things for people, and that is the future of law. So we should not close our eyes to that. We must look at how we intelligently integrate AI into this entire process. Whatever you are, whether you are a court or with an arbitral institution or an ODR platform, you must set a policy for integrating AI into this. Because in coming days, you're going to have courts frown on attempts by arbitrators to deliver AI generated judgments. Okay. In fact, in my own assessment, of two areas where I think AI can write the judgment as a court of first instance, and you provide for an appeal to human being regulated appellate process is check bounce cases and insurance claims cases, because the number of variables in those cases are very, very limited. I mean, how many defenses can you take in respect of a check bounce case? The AA has seen it all, and it knows to apply the principles and roll out a judgment in no time. And likewise, in respect of motor accident insurance cases, once the evidence has been written, the AI can produce a judgment within no time. So all that is going to come in, but we just don't know how effectively. The point is, you can't brand AI as being something harmful to the system and keep running away from it. You can't. You can't run away from it. It's going to be all around you. So it is better that you know how to embrace it intelligently. That's all I have to say.
Absolutely. Thank you for picking on the question that we couldn't ask you, because this conversation was predominantly for people from the NBFC and banking sector on how and what's the legal recourse available to
Why?
them in
See,
view
I
of.
tell you, NBFC and banking, if you are able to, set an AI and generate a system, it will be able to predict who your defaulter is going to be. You know that?
Yeah.
If you
Yes.
feed in sufficient data into the AI 6
Correct.
months before, and you say that a person's default is usually happens on account of ABCD factors. And if
Right.
you keep feeding, for example, you have a company that's borrowed, you have the annual report of the company, you have the financials of the company, you keep feeding it every quarter that is filed to the registrar of companies, you keep feeding it into an AA system. You can develop an AA system which will predict who your defaulter is going to be. So NBFCs and banking sector have huge utility for this. And you can build, JustAct can actually build systems for them, which will help them to predict the defaults.
Absolutely. So the predisposition based on geography, age, location, or
Easily it can
background.
do. At
Right.
least it can, wave a red flag.
Absolutely. Absolutely. Sadly, we have come to the end of the hour. So thank you so much, sir, for gracing today's webinar and clearing concerns and doubts that our participants have in the NBFC and the banking sector. We're all aware of your busy schedule. It's an honor to host you and engaging with you for an hour. I'm quite certain this hour of curt and to the point answers to all the questions, summarizing them in points as a plan of action for the participants to act upon, is really an amazing experience for everyone who attended today. Until we meet next time, thank you to all the participants. Have an amazing weekend ahead, everyone, and take care. Thank you. Have a
Thank you.
good weekend. Thank you, sir.